A warning, this podcast contains content some listeners may find confronting or distressing. Listener discretion is advised.
9 podcasts.
Mystery deepens. Tonight, confusion at the Alva Beach Stabbing Inquest. Will the number one witness be forced to answer questions?
Dean Webber, well, his lawyers are arguing he should be exempt from giving evidence. Lawyers for other families are trying to change that immediately.
The inquest into the stabbing has hit a significant roadblock.
A widow's lawyer and a coroner have gone head-to-head in a dramatic day.
Has seen the widow of one of the victims walk out, and the coroner asked to disqualify herself.
A courtroom turned sparring ring, the inquest hanging by a thread.
Their families listening in tears as authorities get to the bottom of what happened on that night at Alva Beach in 2018.
We just want, obviously, the truth.
For all the confusion stemming from what happened at Alva Beach, I can tell you the Coronial Inquest wasn't much better.
The inquest was supposed to be wrapped up today. That is now very unlikely.
We're at a point here where you may well have already made up your mind about this case, and quite emphatically. And I suspect it's this: that Candice and Louis, through their actions, have a lot to answer for, as do police and 000 operators for their conduct and abysmal delay in getting to Dean's home. Not to mention, maybe alcohol is the real villain here. Meaning, even if Tom and Corey were innocently confused about what was going on, you're thinking a frightened Dean did what anyone would do when strangers force open a door to your home. And that's a fair enough conclusion to come to. It's probably the conclusion most will make. It's even what the coroner seemed to be saying in her findings. But the inquest she oversaw was chaotic.
This. The widow of Corey Christensen, her supporters and her lawyers defiantly storming out of the inquest.
Raising this question: did the inquest fail?
What strikes me about this case is the lack of resolution. 2 people have died in circumstances where the evidence of the key person, the person wielding the knife, has never been tested. And it's not just for the grieving families, but for the community as well. The Coronial Inquest is designed to ensure that as much light as possible is shone on these dark places. It begs the question a bit about whether the coroner got it wrong. Often judicial officers get it wrong.
It's like it's been pulled from a script. That's the Alva Beach case. Problems at every turn. From the people involved that night, to the emergency response, then the police investigation, doubt and criticism was cast over all of it. Then the inquest seemed to do the same at the final hurdle. You just heard from David Heilpern. He's a retired coroner of more than 2 decades. For 6 episodes now, you've heard from people with skin in the game. The heartbroken Davey and Christensen families, a frustrated lawyer who represented them, the lead detective defending his investigation, and a former cop with his own trauma from the night. But here's where we have an interesting and telling shift. David Heilpern's not only experienced and respected, he's also looking at all of this with fresh eyes. That's important. He's had nothing to do with it at all over the past 7 years. We approached him for this podcast. He's reviewed the case and how the inquest was conducted, and he can't believe what he's reading. Putting all the he said, she said aside about what happened that night, from a purely legal perspective, David Heilpern's adamant the law did fail.
In this case, the whole purpose of the Coronial Inquest seems to have been put aside.
Central to his very measured critique is one decision in particular. Something that in many ways becomes the crescendo, the climax of this whole confusing, tragic saga.
The inquest into the stabbing at Alva Beach in northern Queensland was expected to wrap up today, but has hit a significant roadblock.
Dean Webber, the man who killed 2 men, was excused from giving evidence and being cross-examined. In a case this serious, That's virtually unheard of.
And this sums it up, Andrew. Senior lawyers I've spoken to today have said they've never seen anything like this, and they're calling it a farce.
It is unusual.
So, why did it happen? I'm Adam Hegarty. Welcome back to Alva Beach, Death at the Door. This is episode 7, The Key Witness. Like me, Julia Jasper, the Davies lawyer, sat through every day and every moment of that inquest.
You remember that room, that we were jammed into that room. I think I was sitting in the public gallery, balancing my computer on my knee. There was paper and people everywhere. It was chaos. It really was.
She arrived with Heather and Neil by her side with some clear expectations. As the days went on though, the penny dropped for them. They weren't going to get what they wanted.
That the inquest wouldn't be focused on one of the central questions, which is whether or not Dean any criminal liability should be attracted by Dean. So that was not going to be a focus of the inquest. We knew that from day one. There were limitations that were placed into like how long people could question witnesses for, and practical considerations, which I can understand why they were put in place. But from our perspective, were concerning. And, as time went on, we weren't really making the progress that we'd hoped to make. And then when it became clear that Dean Webber wasn't going to be giving evidence and that we found it difficult to understand the reasoning for why that was occurring, we went on and made the best of what we could, made the best of the time that we had and the witnesses that we had, but we knew we weren't going to get the answers that we were most desperately seeking, which is what happened, without an opportunity to talk to him.
The thing is, it wasn't without reason. It was on mental health grounds, Dean Webber's genuine trauma from the night. Very early into the 5-day hearing, the inquest heard from a psychiatrist who'd assessed Dean. Not only did that doctor explain the young man still had PTSD, but that any answers he gave could be unreliable because any cross-examination process would be too much for him to handle. I don't envy the coroner there. What do you decide? To protect Dean's mental health and avoid traumatising him even more? Or do you allow his version of events to be challenged through the forensic inconsistencies and contradictions we've just explored? Remember, Dean's never been asked to clarify any of that.
It's not anything that I've seen happen in an inquest, but often you don't know who's responsible for the death when you're having an inquest, and it's one of the reasons you're having the inquest. Yeah. But it certainly limits the ability for the facts, the ultimate finding of facts that were made to be, properly, rigorously tested, which is what our criminal justice system is set up to do, is to, as far as you can, it's not a perfect system, but it's pretty good about working out what the best version of the evidence is. But that involves testing the evidence, and the only way you can test the evidence of a witness is for that witness to be cross-examined. Because if you're in a situation where the evidence of that witness is perfectly corroborated by all of the other witnesses, by all of the forensic evidence or any other physical evidence, then maybe you don't need to talk to them if we have no doubts about the accuracy of their version of events. But that's so rare. People aren't like that. Even with their best intentions of being honest and reliable, people's memories don't work like that. So a person can come and give evidence that they believe is really everything that they can remember, and it can be completely contradicted by the physical evidence. And it's not because the person's lying, it's just because memory is fallible.
Well, knowing that, what was your reaction when you realised that he wouldn't have to give evidence based on his mental health and traumas?
I was disappointed for my clients, really disappointed for my clients, and they were devastated by it, obviously.
When in that inquest did you sit there and think, we're not going to get what we were after here?
Do you know what? I still, on that 5th day when we were there, I thought at the end of it, or when we first went in, I thought, I could not imagine that we would not have that course of justice that we believe in. Still on that 5th day. And then when she said that he was not to be questioned because of his PTSD, that was not good.
How difficult of a process was that for both of you when you realised that it just wasn't playing out the way you had envisioned?
It was extremely difficult, and it made me very angry. normally a very calm person, but that made me very angry that we believed so much that, you know, that this would happen.
And not have to be questioned after you've done this just horrible, tragic thing. How could you not question the person that did it? That's just insane.
Even if you don't agree with Tom Davey and Corey Christensen's families, here's what's important to understand. The inquest questioned everyone else. Everyone who might hold even the seed of an explanation. Louis Bengoa,
So drunk he barely remembers a thing about crucial details.
Candice Locke,
She now doesn't know if she was pushed or fell from a buggy, causing...
lead detective Gavin Neal,
questioned for hours. The man who chose not to charge the 19...
the officer on scene, Justin Luke,
breaking ranks as he gave evidence. He was
even 000 operators.
Communications centre operator, revealing the cause of the delay.
5 long days trying to eke out intimate detail about the events and the emergency response from every perspective, but not from the young man who wielded the knife and stabbed Tom and Corey.
Well, the coroner's decision to excuse Dean Webber from giving any evidence in person at this inquest about how he killed 2 men has been hugely upsetting for their families.
No questioning or challenging of Dean about where he killed them, how he killed them, the threats he described, or the blood evidence not adding up. We've reached out to Dean, his family, his lawyers. We've tried to call him. He doesn't want to speak now either. And as I've said, I know a few people from up in North Queensland. I know Dean's considered to be still traumatised by what happened. As we're trying to present all the facts in this podcast, that includes telling Dean's side, even if he doesn't want to speak to us. The coroner does that for him. Before we pick apart what happened in the courtroom, let's jump forward to the coroner Jane Bentley's eventual written findings. Most of the 55 pages are littered with words such as likely and probably, because there are very few rulings she could make beyond all doubt. But here are a few things she is emphatic about when it comes to Dean Webber. She says,
I find that Mr. Webber was genuinely concerned for his own safety and well-being and that of Ms. Locke when he made the first call to 000 and continued to be so until the arrival of the police. I find that by the time Mr. Christensen and Mr. Davey removed the glass door, Mr. Webber was very much in fear for his life.
You're probably feeling the same way. It may very well have been reasonable, necessary self-defence in the way Dean described on the night. But as you know now, there are things that don't add up. And you know what? The coroner knew it too. This is where, in that courtroom, things got very messy. You're about to hear what the coroner, Jane Bentley, said in court, read by an actor, as she considered Dean's PTSD and after she heard from Dean's psychiatrist.
I accept his opinion that giving evidence in person will cause Mr. Webber considerable psychological distress and decompensation of his symptoms of post-traumatic stress disorder, and, relevantly, may also result in his inability to assist this inquest in any meaningful way. I am, however, satisfied that there are some inconsistencies remaining in his evidence internally, and also inconsistencies between his evidence and other evidence which has been adduced in the inquest, which need to be explored. And that Mr. Webber is the only person who can provide information about matters that are of significance to the inquest.
To reiterate, that's the coroner conceding that. So she tried to make a controversial compromise.
She indicated here at the inquest today she'd prefer Mr. Webber to give written responses to written questions because of his mental health.
That she wouldn't make Dean appear in person, but instead, lawyers would be able to submit to Dean written questions that he could then answer within 3 days with the help of his lawyer.
The lawyers for the families are having none of that. They've already threatened to dispute that decision or any decision like it in the Supreme Court.
The Davey and Christensen lawyers did challenge that decision in the Supreme Court. They wanted to question Dean in person, despite his proven trauma. But the court sided with the coroner, and in the end, Dean didn't give any evidence at all.
for that to be the primary consideration as over, the interests of the other people involved in the inquest but there wasn't any sort of attempt at a balancing act. It was just simply trauma will be caused. I will not cause this trauma, so we will not call him, and I'm not sitting in the coroner's shoes, making these difficult decisions, and I'm biased. I accept that I'm biased. I'm a criminal defence lawyer, of course I'm biased. I want my clients to have the best possible experience they can in the criminal justice system. So I want the Davies to get what they so desperately want, which is answers about how their beloved son, who was accused of heinous things in the media in the wake of this, for his memory to be rehabilitated and for them to actually know what happened to him. And you've met the Davies, they're not going to rest.
A big reason why they won't is because of what they sat through in that inquest. It became borderline theatrical. Despite everything I've just explained, and the coroner deciding Dean was too traumatised to take the stand, on the morning of the final day, what did the inquest do? It called Dean on the phone. It was a formality to put on the record that Dean would refuse to give evidence. The mental health concerns weren't mentioned though. Instead, Dean said these words to the court as the Davies and Christensens sat there listening. "I declined to give evidence because the evidence would tend to incriminate me." Now, that's a scripted line you hear a lot in inquests. It's not uncommon at all. But imagine hearing Dean say that when you have questions you're desperate to put to him. It's frustration that all led to quite the sensational moment. Yes, another one.
A widow's lawyer and a coroner have gone head-to-head in a dramatic day at the Alva Beach inquest.
The solicitor and barrister representing Jay Christensen, Corey Christensen's widow, were so agitated at how the inquest was being conducted, they even demanded midway through the hearing that the coroner overseeing it, Jane Bentley, disqualify herself. They argued in front of the coroner that she had a so-called apprehension of bias and that she'd prejudged some of the issues. Effectively, they claimed she had already made up her mind and wasn't taking key evidence on board. And of course, they had issue with her decision to excuse Dean from the stand.
Dean Webber is the one truly critical witness who can shed light on what actually happened at the critical moment, James Godbold told the court.
They even decided there was no point in them being there for the rest of the day and walked out.
The coroner refusing to step aside or concede she'd relied too heavily on Mr Webber's previous statements to police. "I cannot see that it was inappropriate. I had to take into account his prior versions."
When I was sitting in that inquest, the most shocking moment for me was when you had two lawyers storm out. So the Christensen's lawyers walked out.
Halfway through the last day.
So disgusted in the process that they walked out. Now, whether that was to create theatre and to make a point, or whether they were just genuinely
had enough. Yeah.
I mean, have you ever seen that? What was your reaction?
I've never seen that before. I mean, I think that they would have made the assessment that there was nothing further that they could get from the inquest, that based on, the decisions that would be made, that they'd done everything that they could possibly do.
I've been in court a few times, less than you, but I've been in a few times. I've never seen anything.
No, I haven't either. I can understand their frustration. We were all feeling it, but I can understand why they did it.
Now, lawyers for both the Davey and Christensen families will be challenging the coroner's decision in the Supreme Court. For now, though, the inquest is adjourned, and in doing that this evening, the coroner has just addressed those two families in court. She said, based on all the evidence she's heard over the past 5 days, she said to them that both Tom and Corey, in her mind, are good people and good men. Andrew, it brought them to tears.
Our family is completely devastated by the loss of this kind, loving, generous and empathetic man that Tom is.
As the days went on, you could feel the tension building, from the lawyers and even the coroner having her conduct questioned. But in particular, the families were at breaking point.
This week is something that no family should ever have to endure. Our beautiful Tom is not here. He's not living his life, surrounded by his loving family and friends.
For me,
for my family, for Corey's family. I think we just want, obviously, the truth.
Well, it's very unusual, and I've never seen circumstances like this before. Indeed, this is crucial evidence. And in this case, the whole purpose of the Coronial Inquest seems to have been put aside. The whole purpose is to see and to work out and to give particularly members of the grieving families some knowledge of what happened. And I can understand their sense of disquiet because the process has not led to testing of the evidence as to what happened.
I introduced you to David Heilpern at the start of this episode. We've called on David here to be an unbiased, measured legal expert. And he says the inquest got things wrong. Well, David, can you just give me an idea of the extent of your legal experience and the roles you've held?
Sure. So I was a solicitor for 10 years and then I became an academic for 10 years and I became a magistrate for 22 years, and that included the role as coroner. Following that, I've become the Dean of Law at Southern Cross University.
With that in mind and that extensive experience in mind, what strikes you about this case?
What strikes me about this case is the lack of resolution. 2 people have died in circumstances where the evidence of the key person, the person wielding the knife, has never been tested. He gave an explanation to the police that was inconsistent, and then he was never called in the first inquest. And so what strikes me is that we're left with so many questions and unresolved questions as to how and in what circumstances these people died. Look, I think in many cases like this, there's a series of decisions that are made, and when you look at individual ones, they seem arguable. But I think that anybody who looks at the big picture, at the fact that we just don't have tested evidence, what we have is 2 people who are clean skins with no history of violence, who enter a house, at least one of them presumably having been told that a woman is in danger. They're in an isolated area, and both of them have ended up stabbed to death. One of them with 6 stab wounds and the other with 2. That is an extraordinary situation. The thought that it is left where it is now leads to obvious dissatisfaction for the families of those deceased people.
You understand why these families would be upset and frustrated, but from a purely legal perspective, did they get it wrong?
I think they did, yes. I think that the inability to test the evidence of the knife wielder has left a big gap. And it's not just for the grieving families, but for the community as well. The Coronial Inquest is designed to ensure that as much light as possible is shone on these dark places. And without testing the evidence, it's hard to see how that primary function has been fulfilled. It could be that he satisfies everybody, including the coroner, that he was acting entirely in self-defence. It may be that more light is shed on that situation and questions are raised, but in the absence of that, there's no conclusion as to what really occurred.
The core reason given for why he didn't give evidence was his mental health, his PTSD, and Dean Webber's trauma. Is that ever an appropriate reason for someone who's killed 2 people to not give evidence at an inquest?
I've seen circumstances where peripheral witnesses are excused because of their mental health, and I think we've seen that in civil cases and criminal cases as well. But that's why we have a provision for reopening inquests. We don't know what his mental health condition is now, and we don't know if he can give evidence now. There's always a balance test to be applied as to the community's right to know and the aggrieved family's ability to test evidence in a coronial inquest, and the health and well-being of witnesses. Where you've got a crucial witness, and in this case really the sole witness, then that bar becomes higher and higher for a decision to decline to require that person to give evidence. And in this case, the coroner came up with a solution of allowing the parties to provide written questions to the knife-wielding person, and that apparently was never followed through because it's such a indeterminate process. So I don't know what his mental health's like now, and the only way to find that out is to have an inquest, and he can be heard, of course, on issues about whether that test is now met, the public interest versus his mental health interests. And that's a strong reason for reopening, I would have thought.
What questions do you want Dean to finally answer?
There's too many inconsistencies in his statements. There's too many inconsistencies in there, and our barrister, who unfortunately has passed away since, we started with him, he's a wonderful, wonderful person, wonderful barrister. He wrote a letter to the state coroner and outlined all the inconsistencies. But if you look at that just alone on anything, there should be another inquest.
This case has a real knack for eliciting strong responses from anyone who gives it more than just a passing glance. That includes people jumping to Dean's defence, just as passionately as these lawyers are infuriated at how it was all handled. I'm going to share with you now something that really got me over the line to delve back into this case. It's a letter written by the Davey family's barrister, Chris Minery, to the Queensland State Coroner. It was after the inquest findings were handed down, and he demands a second inquest. It really, I feel, goes away to explaining why you should care if you've got nothing to do with the people involved. Here's a barrister so worked up he's written 21 pages to the coroner's superior, listing out grievance after grievance with what the inquest did and did not consider.
We had to go through so many drafts because it was even more scathing when he first wrote it, and I had to go through and tone it down because he was so furious.
He writes things like, the findings were contrary to the evidence and clearly wrong, that the police investigation relied upon was lacklustre and inept, and then this about the decision to excuse Dean from the inquest altogether. It is an appallingly dangerous precedent to set, one which may well defeat the purpose of an inquest. You can't get much more critical than that. Did Dean Webber's lawyers find a loophole?
It's unclear. Perhaps they did. I think we all know of cases where mental health has been used for people to avoid giving evidence. On the other hand, one can imagine that it would have been an horrific situation that Mr. Webber found himself in. So I don't know the answer to that, whether it was a loophole or whether the reasons were genuine. There was medical evidence that was given in the original inquest and a decision was made. But in a way, that's water under the bridge. The test is now, what is his mental condition in terms of reopening an inquest.
What would the bar be there for you, do you think, for him to still be excused from giving evidence at potentially a second inquest? There's no doubt that he is traumatised and that he was traumatised at the time, but you're quite right, he's the key person who holds key answers here.
The bar would be very, very high indeed, because the community interest and the aggrieving family's interest in finding out, in the words of the first coroner, what happened is so high. And there are plenty of other authorities to suggest that key witnesses who want to be excused from giving evidence have a much higher bar than those who are peripheral, who could do an affidavit or answer questions in writing. So the bar would be very high indeed. It begs the question a bit about whether the coroner got it wrong. Often judicial officers get it wrong, and that's why we have a process of appeal, and in the coronial jurisdiction, even better than an appeal, is the ability to reopen as time passes, because I think we know that people with treatment and assistance can resolve matters like PTSD to the point where they can give evidence. And that's one of the good things about the coronial jurisdiction, is there is provision to reopen. Of course, that was rejected by the state coroner, and here we are.
If Dean suffers from PTSD to such an extent that being asked about it, he wouldn't be able to give genuine responses, would that be the only really reason for not having him give evidence and relying on what he's already said instead?
That's certainly the high bar that I would look to. And it would only be a real inability to give evidence, in my view, that would appropriately stop a court from requiring him to do so.
I suppose you don't want to unnecessarily traumatise people either, right? But could that reason alone be reason to not have his version of events be tested?
There's a balancing test, and the balancing test is always the rights and protection of the individual who's about to give evidence or who's wanted to give evidence, and the community interest. And in this case, the community includes, and specially includes, the families of the deceased persons. And as a general rule, the community interest, and those interests in particular, are going to outweigh almost everything else, because the alternative is A, it invites declining to give evidence in other cases, but B, because otherwise we're left in this situation where there are families and children of deceased people who just don't have answers.
That's a slippery slope, isn't it?
It is, yes.
We have not got a fair go here. If they have nothing to hide, the legal system has to be let to do its job. It has to be.
Because he's taken 2 lives. We live in Australia. He's taken 2 lives. He needs to be accountable. And, you know, if at the end of that system that we believe in, all the evidence is presented, if it came out at the same result, then we would have to live with that. But we haven't had that, and that's what we want.
The Davies and Christensens had to wait and wait for an official response to their pleas. In fact, for years, Barrister Chris Minnery's scathing letter I read to you earlier went unanswered. It wasn't until the year this podcast is being recorded, 2025, several years after the inquest, that they were given reasons why a second inquest would be denied. But remarkably, in doing so, the man refusing their plea, the Queensland State Coroner, revealed a final head-scratching twist.
And that's something we didn't know about, can I just say, that we only found that out when we got the letter back from the coroner.
In the final episode of Alva Beach, Death at the Door, a fittingly strange revelation for this already drawn-out saga.
I've not heard of that process occurring before.
We will go back to the courts and we will make the arguments, the complicated technical legal arguments that will need to be made to get it reopened, and hopefully we'll be successful.
And why these families and their lawyers won't just let it go, even if you think it's time they did.
I just want to know. I just want his side of the story, that's all.
It's what the criminal justice system is built on, and what the coronial function is. That level of uncertainty should concern us all.
Alva Beach Death at the Door is a 9 podcasts and 60 Minutes production, written and presented by me, Adam Hegarty, with 60 Minutes journalist Serge Negus contributing to this episode. The producer is Jess Lodge, editing and sound design by Maddie White.